my title and some of my slides a number of times since then, because there's been a lot of developments that have come out in the last couple of months that could affect this whole space as we go on. So my plan today is to discuss what the Title IX regulations or guidance that was in place under the Obama administration was, how that changed with the regulations that became final in August of last year, and what we foresee coming up from the Department of Education the next couple of years, or how they plan to interpret those regulations. The first is, this is a presentation only providing general information. We don't give legal advice, and there's no attorney-client relationship between us. So what is Title IX? Title IX is part of the Education Amendments. It protects people from discrimination that's based on sex in education programs or activities that receive federal financial assistance, and that would include both the students and the employees. When we talk about schools that receive federal financial assistance, it includes your public schools, for instance, because they receive money from the state and from the federal government, although that federal government money usually flows through the states. But it also includes, in the higher ed space, direct loans or any sort of financial aid that comes from the government as well. So the only educational institutions that really didn't have to deal with Title IX, some until fairly recently, were private schools who often don't receive federal money. But what we saw when the PPP loans came out and the other monetary assistance for the COVID relief is that if independent schools had taken a PPP loan or received some other financial assistance, that the guidance that was starting to come out a lot of times after they had taken these loans was that the schools needed to also be compliant with federal discrimination rules, which they previously did not have to do, and in particular Title IX. So over the last 8 months or so, I've actually been drafting Title IX policies for some private schools that never had to have this in place before, because now they're subject to that because of whatever financial assistance that they took. We'll get into it a little bit later, but the regulations do have a few different rules for K through 12 schools versus post-secondary institutions, although those differences, for the most part, and the whole intention behind the regulations of providing a fair and equitable process for both parties is going to be applicable to all schools. So just to give you a little bit of background in the status of the Title IX regulations, Title IX was enacted in 1972. There were final regulations, which were very light on content, I think it would be fair to say, were issued in 1975. And then, between 1975 and around 2011, a lot of times people who didn't work in at least the education space, their connection with their recognition of Title IX was for, in the sports context, with girls' sports being funded and receiving the same benefits that boys' sports did, both at school in the undergrad space as well as in K through 12 schools. In 2011, the Department of Education released this Dear Colleague letter, which put the focus a lot more on how schools should respond to reports of sexual harassment. And in that definition of sexual harassment, we include sexual assault to ensure compliance with the Title IX. And then so the 2011, the Dear Colleague letters under the Obama administration that we were talking about. In 2018, the first proposed rule came out under the Trump administration to formally amend the Title IX regulations for the first time. Some of the criticism that they had with the 2011 Dear Colleague letter and some of the question and answers that had come out under that administration was that if the Department of Education was going to be telling schools how to implement Title IX, they should have done it through a more formal regulations process. And so pretty early on, the Department of Education identified this as an issue that they wanted to spend a lot of time working on. And so in 2018, they started doing that notice and comment period and hearing from stakeholders about what their proposed regulations would be and what, if any, changes should be made to them. The final regulations were released in May of 2020. They were published in the Federal Register that same month, and then they became effective in August of 2020. As you might imagine, schools were not thrilled with this date, given that they were dealing with a whole host of COVID-19 issues, including outbreaks on campus and how to get kids on campus and what their schools were going to look like if you were teaching classes on campus versus not. So a few lawsuits were brought trying to delay that date, and similarly just appeal to the Department of Ed to say that they were going to delay the date that these regulations became effective. Those suits were not successful, and the Department of Ed's response was essentially, well, you knew these regulations were coming, so you really should have prepared before now to enact them. So the fact that your general counsel's office is very busy dealing with all of these other issues is not going to prevent us from making these regulations effective. President Biden's campaign, was one of the issues that he brought up, was that he wanted to go back to the Dear Colleague letter from 2011, and that in his opinion and a lot of people's opinions, the pendulum had swung too far to it being respondent friendly on the Title IX regulations. And then in March 8th, President Biden signed an executive order that directed the Department of Education to review all of the regulations, including the Title IX regulations, and propose findings on what they think should be done with those regulations in 100 days. Since that time, also the Department of Education secretary has sent out a letter to students, staff, and stakeholders stating that their roadmap sort of to how they're intending to review these regulations is they're going to have what essentially is their town hall meetings to receive comments, both written and verbal comments from stakeholders about what their experiences with the Title IX regulations have been. They're going to issue question and answers document, which will essentially tell schools how the Department of Education is going to enforce those regulations. And then they basically hinted that what will be coming down will probably be proposed new regulations and changing the regulations again, followed by a comment period on those regulations. So increasingly, Title IX issues have been in the headlines. Recently, LSU's had a pretty public issues with holding an internal investigation, and that found that they had an inadequate system for reporting sexual misconduct that basically discouraged victims from reporting abuse. Initially, that investigation was centered on their athletics department, but it's been expanding. The University of Nebraska has had a similar issue. There's a lawsuit that alleged that the school handled sexual misconduct complaints against student athletes differently than other complaints. There's a lawsuit against the Department of Education asking that the religious exemption that we'll get into be declared unconstitutional because it's not fair to LGBTQ students. And recently, some of the religious schools that were mentioned in the complaint have moved to intervene as defendants in the lawsuit so that they can defend why they should be excluded from complying with the regulations as well. And also there's a Berkeley high school that has sued the Department of Education, arguing that these regulations reduce federal protections against sexual violence and harassment. So one of the things that it's important to think about when we talk about these Title IX regulations is what is the definition of sexual harassment? Under the Dear Colleague letter, the definition was fairly broad. It was unwelcome conduct of a sexual nature. It includes unwelcome sexual advances, requests for sexual favors, and other verbal, nonverbal, or physical conduct of a sexual nature. Sexual violence was was specifically included as a form of sexual harassment. Under that definition, a single isolated incident could be enough to have someone be held responsible for violating Title IX. The new regulations came up with a more specific definition for what is sexual harassment. It needs to, in order for the allegation to fall within Title IX, it has to fall in one of three categories. There's the unwelcome quid pro quo, where the harasser is offering something to the complainant in response for participating in unwelcome sexual advances. There's unwelcome conduct on the basis of sex that is so severe, pervasive, and objectively offensive that it denies a person equal access to their education. Here, it is unlikely that a single isolated incident is going to meet this definition because it needs to be pervasive and severe. And then there's one remaining category for an incident that meets the definition of sexual assault or domestic violence or stalking under the Clery Act or the Violence Against Women Act. Where a lot of the debate over whether or not a certain complaint will fall under Title IX is on that second definition there about whether or not it's severe, pervasive, and objectively offensive, that it would affect someone's access to their education. So one of the major requirements of Title IX is that the school designate a Title IX coordinator. The Title IX coordinator needs to be an employee who will coordinate the school's efforts to comply with their Title IX responsibilities. In K through 12 schools and most K through 12 schools and some smaller higher education institutions, what they've decided to do is to make the Title IX coordinator role one of an employee's responsibilities who probably hold another title. Oftentimes, they're in the Dean of Students realm. Occasionally, I've seen public safety officers designated as the Title IX coordinator, or somebody that falls within the provost's area. For larger institutions, the Title IX coordinator is often its own designated role, and depending upon the size of the school, there actually may be more than one person that's in the Title IX coordinator's office. There could be a variety of deputy Title IX coordinators, and oftentimes they might be assigned to certain departments. So there might be a deputy Title IX coordinator who deals with the athletics department, a deputy Title IX coordinator that deals with the faculty issues. And they all sort of report up to the main Title IX coordinator. And then there's sort of all sorts of aspects in between. So the school's responsibilities is to notify the groups of people that I've listed here of basically how to contact the Title IX coordinator, who that Title IX coordinator is, what their office address and email address is, and their telephone number, so that these students, employees, applicants for admission, applicants for employment, and parents or guardians can contact the Title IX coordinator with any reports. And they have to notify the unions too that are on campus. Also, schools are required to prominently display on their websites the required contact information for the Title IX coordinator as well. Where this sort of catches schools up sometimes is when they have the Title IX coordinator role change from person to person, especially those that don't have a designated Title IX coordinator. One of the things that's important for them to remember is we need to update all this information with the new person that we've now designated as the Title IX coordinator. And the sort of first thing that occurs whenever Title IX is potentially triggered is that a report is made. It's very important to distinguish the definition here of a report from a complaint that I'll get into a little bit later on. So any person can report sexual discrimination, including sexual harassment. It doesn't need to be the person who has experienced the discrimination or allegedly experienced the discrimination. It can be any sort of bystander. It doesn't need to be someone who's a part of the college. It could be a report from someone outside the college or the school. Parents and guardians can make reports, especially in the K through 12 space, and we'll talk about that a little bit later. The reports can be made basically all the ways that we communicate with people today: in person, by mail, by telephone, by email, or any other way that the Title IX coordinator has put out there to make a report. So a lot of schools sometimes have like a specific reporting system for taking in Title IX complaints as well. And then once the school has received a report, one of the issues that has sort of come out with the change in Title IX regulations is what does that mean for the school? And when does the school have an obligation to act? So under the new Title IX regulations, the school has a duty to act when it has actual knowledge that there is a potential violation of Title IX. Actual knowledge under the regulations is defined as notice of sexual harassment or allegations of sexual harassment to the Title IX coordinator or any official of the school who has the authority to institute corrective measures on behalf of the recipient. The schools can also designate certain people on campus that can receive confidential complaints under this definition. So before, the concern was always, before the Title IX regulations, one of the concerns was the definition for when a school could be held to have notice was a lot broader. So for instance, if a student had told, their professor that they were being harassed, the Department of Education could take that as as an instance when the school knew or should have known that there is a potential Title IX violation here. The problem was if students had a relationship, for instance, with a certain professor on campus and they wanted to discuss with them what they were experiencing, but not necessarily file an official Title IX complaint. A lot of schools, because they were afraid of what would trigger their obligation to respond, would require all of their employees to report that information up. Now schools have the option to designate sort of confidential resources on campus where students can go and speak to maybe a nurse or maybe someone in the counseling department or maybe a professor to decide, to share what their experience is, maybe decide what they want to do without worrying that that person has to say, okay, you can tell me what you're going to tell me, but I may not be able to control whether or not that's confidential or not. And then the Department of Education was actually trying to confer on schools a benefit in that schools are only going to be held responsible when it's shown that they were deliberately indifferent to a Title IX violation, which the Department of Ed describes as clearly unreasonable in light of known circumstances, which is a pretty high bar to have to cover in order to be found deliberately indifferent. A response to a potential Title IX violation needs to be prompt, and an important part that came out of the regulations that I think is likely to stay is that the Title IX coordinator has to contact the complainant confidentially and to discuss with the complainant what supportive measures that they would like and that they need in order to continue to receive their education. Supportive measures are defined as non-disciplinary, non-punitive, individualized services that are offered as appropriate, as reasonably available, and without fee or charge to the complainant or the respondent. When we say non-disciplinary or non-punitive, that's actually referring more to the respondent. So for example, I had cases before these regulations came out where, two college students might be in the same club, and they might be dating, and things don't go well, one student makes a complaint against the others, the school would issue a no contact order, and it would essentially say, you respondent, person who's alleged to have committed a Title IX violation, can't participate in this club anymore because you can't contact each other. So, the victim, who we see as the victim of the crime, is going to be able to participate. You are not. That's not going to be allowed under the Title IX regulations. The supportive measures here cannot, until and unless there's a finding of responsibility against a respondent, they cannot punish or discipline the respondent just because a complaint has been made. which has made making these no contact orders on campus certainly much more tricky. A complainant's wishes regarding the supportive measure needs to be taken into account, although I counsel schools that in advance, before they have a Title IX complaint, they should identify what, at a minimum, they're going to offer as supportive measures when they have this conversation with the complainant. These supportive measures are available to a complainant with or without the filing of a formal complaint, and we'll get into a discussion of what a formal complaint is in a minute, but they also need to review with the complainant what the process is for filing a formal complaint. The other sort of changes from what mandatory reporters were that we were talking about with regard to notice is under the new regulations, all elementary and secondary school employees are federally mandated reporters of Title IX violations. And the justification behind that was these employees are already mandated reporters under state law for potential child abuse and neglect violations. So we might as well just make them Title IX mandatory reporters as well. And as we talked about, colleges and universities can determine for themselves which are the employees that have authority to institute these corrective measures. So what triggers an investigation once a Title IX report has been made? Schools have to investigate sexual harassment allegations in any formal complaint, which is a complaint with allegations that is signed by either the complainant or by the Title IX coordinator. Generally, complainants' wishes with respect to whether or not the school is going to initiate the investigation phase are going to be respected unless the Title IX coordinator determines that they need to sign a formal complaint over the wishes of the complainant, and that decision's not clearly unreasonable in light of the known circumstances. Where we see that a lot of times a Title IX coordinator might be facing that decision is if a complainant doesn't want to go forward with the complaint, but either the allegations are so concerning that the Title IX coordinator is concerned that the respondent potentially could be a danger to other students on campus, or if, for instance, there's multiple allegations against the same respondent, if none of the complainants want to go forward, the Title IX coordinator may decide to sign a formal complaint themselves because this person, again, is showing themselves to be more of a danger to others, and they need to protect the school body generally. So as I mentioned before, the formal complaint is a defined term. It's very different than an actual report. The document needs to be signed by the complainant or the Title IX coordinator, and it has to request that the school investigate allegations of sexual harassment. Thankfully, in this time of COVID, when people aren't really signing a lot of documents in person, it can also be by an electronic submission and include a digital signature, but it needs to indicate that the complainant's the one filing the formal complaint. The formal complaint the document's only going to be accepted as a formal complaint if it's the respondent and the complainant are participating in or attempting to participate in the education program or activity with the school that's alleged in the complaint. So for example, what I saw before the regulations came out is if you had I had a case where I had a defendant in a criminal case in Connecticut about allegations of activity that occurred in Connecticut with a former high school girlfriend who did not attend his secondary school. He was going to a higher ed institution in Ohio. So basically the only connection that his Ohio school had with Title IX and the sexual assault complaint was that they had in common this respondent. And then he would have to so while this criminal case is going on, he then would potentially have to defend against a allegation that's at his school in Ohio, even though this didn't occur on campus, it didn't involve people that went to the school otherwise, and which was a much more trickier situation. Here, one of the definitions that the Department of Ed has found to be very important is that you need to be participating in or attempting to participate in the actual activity. So the complaint I just described under the new regulations would not be considered a formal complaint because the complainant, the person alleged to have been assaulted, was not participating in the Ohio school's education program or activity. And then other requirement is that the Title IX coordinator needs to send written notice to both parties, the complainant and the respondent, of the allegations upon the receipt of a formal complaint. There had been some consternation about this requirement because you might have a complainant come in, talk to the Title IX officer and say, decide later on that they didn't want to go forward with the complaint. But once it was signed and this process started, the respondent had sort of received notification, and they didn't want the respondent to receive notification, or they weren't as sure what the process would be before, like, sort of the train left the station here. And so what schools have done is, some schools have done is they sort of start the conversation with the potential complainant with, this is the process, what you tell me, you know, if you decide to go down this road, it's not going to be we might not be able to keep your name confidential, before they start talking about what their allegations are, so that at least when the complainant comes in to make a potential report or file a formal complaint, they're aware of what the process is, whether or not it's going to be confidential, and what they can expect. One of the other bigger changes that happened with the new regulations is what geographically falls within the school's jurisdiction. So under the Dear Colleague letter, generally all off-campus locations would still be considered, you know, potentially involved within a Title IX complaint, as I described in my example. Under the new regulations, the off-campus locations that a school is going to be responsible for are only those in which it exercises substantial control. So for instance, one of the issues that I had dealt with a school prior to the regulations were an app that students were using to sort of harass each other potentially, or bring up issues of sexual misconduct. And you know, their response was I could be responsible for what happens on the app, but I have no control over the app whatsoever. It wasn't tied to the school at all. And that's, under the new regulations, that's not an issue for them. They're not going to be responsible for that. What they may be responsible for, because they exercise substantial control over that, is their email system, any sort of forums that the school puts on themselves. The Title IX regulations also specifically stated that the conduct at issue needed to occur in the US. So this relieved a lot of issues that came up under the Dear Colleague letter with, what do we do in a study abroad program where the allegation is that something happened to a student while they were studying abroad, and you know, that's through the University of London and I have no control over what happens there. So there is a specific grievance investigation process that occurs, and this applies to all schools equally, including the K through 12 schools. The guiding principles in the investigation and grievance process is transparency. The parties should know what's going on and what to expect, and deadlines. Consistency. The school should apply its regulations and its policy consistently every time. And equitable treatment, which especially comes up again when we talk about the supportive measures and making sure that during the investigation and grievance process and up until if there's a finding that the respondent was responsible, both parties are being treated equally. One of the criticisms that was under the 2011 Dear Colleague letter was that it was too preferential to the victims or the complainants in cases, and it wasn't fair against respondents. And now, as we'll go through some of these, I'll explain how the complaints about these regulations have been that the pendulum has swung too far towards the respondent of complaints, and where we're thinking is that the pendulum might swing a little bit more towards the middle this time, once the Department of Ed decides what it's going to do to change these regulations. So, and then there's two parties, there's a complaint and a respondent. I put these in the singular, but sometimes there could be multiple complainants against one respondent. Sometimes one complainant could be bringing a complaint against multiple respondents. It's not limited to just one complainant and one respondent. Under the timing of an investigation, under the Dear Colleague letter, there weren't requirements for timing, but essentially, you know, the average was it took around 60 calendar days. The new regulations really emphasized having reasonably prompt timeframes, and being transparent and informing the parties if there's going to be a delay or a time frame and what the cause of that may be. So, it's not uncommon that for very serious allegations, there might be a police investigation going on at the same time as your Title IX investigation, and the Title IX investigation is not reliant or not tied to the police investigation. But as you might imagine, the police don't like when the Title IX officers are interviewing the same people they want to interview and potentially interfering or, changing recollections or anything. So there is some tension there. And oftentimes it's important for schools to sort of have a good relationship with the municipal police department or the state police department to sort of smooth these issues over. As part of the being fair and equitable to both parties, the regulations came out and said we're going to define complainant and respondent. And the reason for that is because we don't want to refer to the complainant as a victim or the respondent as a perpetrator because there hasn't been any finding yet as we're going through this investigation and grievance process. And the Dear Colleague letter didn't require there to be these sort of less judgmental terms. So a complainant is the individual who's alleged to be the victim of conduct that could constitute sexual harassment, or the parent who is legally authorized to act on behalf of an individual. So in the K through 12 schools, the parent can sign the complaint. The respondent is an individual who has been reported to be the perpetrator of the conduct that could constitute sexual harassment. So who can conduct the investigation? Title IX personnel have to be free from conflicts of bias against complainants or respondents, and there's a lot of training that is required under the regulations. Generally, the way there's training that's specific to the hearing officers. So here, for example, I've listed out what the different types are, but how the technology is used at a live hearing is something the hearing officer needs to be trained on, not necessarily the Title IX investigator. But in my experience, the schools think it's just easier to have everybody trained at the same time. So they cover sort of soup to nuts, your definition of sexual harassment, the scope of the school's education program or activity, how to conduct an investigation, what the grievance process is going to be that the school has laid out, how to serve impartially to avoid prejudgment of facts, conflicts of interest and bias, issues of relevance, which also include how to apply the rape shield protections, the technology, and then these training materials that are used need to be posted on the school's website. And I have heard fairly recently that OCR was receiving some complaints and pursuing them against schools that had not complied with this requirement, but as soon as the school posted the training materials, they dismissed the complaint against them. So what is the role of the Title IX investigator in the investigation? During the time period of the Dear Colleague letter, often a school might just have a single individual, which could be the Title IX coordinator, who facilitated the whole process, including potentially doing the investigation themselves, coming up with making the decision of who was responsible or not responsible and what that punishment could be. Under the new regulations, there's now two roles that need to be filled by two different people. There's the investigator and the decision maker. The Title IX coordinator can be an investigator at times, but not the decision maker. So oftentimes I see schools that do use their Title IX coordinator to do investigations, especially the simpler investigations, but as you might imagine, there's a large body of people that also are investigators, both lawyers and non-lawyers. And then the decision maker in the context of a higher education school will be the person who oversees the hearing process, and in a K through 12 school that chooses not to have a hearing process will receive the investigation report and then make a decision. Advisors are a new concept that came up under the regulation. Under the Dear Colleague letter time period, complainants and respondents weren't required to have advisors. In fact, most schools did everything from overtly saying they could not participate in the Title IX process, to if a student who, oftentimes the respondent brought in a lawyer who they wanted to represent them, they would allow the lawyer to sit next to them during a hearing, for instance, and just not speak, which was not terribly effective, as you might imagine. Under the new regulations, a complainant and a respondent need to be informed that they can have an advisor who can but need not be an attorney. And parties have the same opportunity to select an advisor of that party's choice. So how I've seen this sort of work is, for, especially in times when there's a law enforcement investigation, or that there's actually a prosecution going on at the same time, respondent may have their lawyer be their advisor through the Title IX process as well. But even if there's not a law enforcement allegation or investigation going on, respondents typically are more likely to hire themselves a lawyer to represent them in these processes, but I've seen complainants do it too. But if a respondent brings in a lawyer that they're going to pay for privately, the school needs to still offer to the complainant an advisor, although that advisor still doesn't necessarily need to be an attorney, just because the respondent is paying for an attorney themselves. And a lot of schools have come up with basically a list of people who they've trained to be advisors, and they tell the complainant and respondent, you can pick someone off the list. Each advisor advocates for their party and has access to the same information as their party. So, for instance, you can't say only the complainant respondent can come in and take a look at the investigation report or review whatever the potential evidence is. Their advisor has to be able to do that as well. And then the goal of these regulations was to essentially put a due process component into how schools handle these investigations. So under the Dear Colleague letter time period, there wasn't really any clear guidance for what due process was meant to be. Although certainly since that time, there was a number of lawsuits that were filed both under the Dear Colleague time period as well as the new regulations time period, where respondents or complainants at times have asked the courts to basically input this due process requirement and interpret that in how these hearings were held. Under the regulations, it's very clear that a respondent is innocent until they're proven guilty. They need to be told that when they receive the notification, and that there's everybody involved, including the hearing officer or decision maker and the investigator, need to know that they cannot presume that a respondent is not responsible for the alleged conduct until a determination is made. And then, as I mentioned, there's a live hearing process for universities and colleges, and there's an option at the K-12 through 12 level to have a hearing. I'm not aware of any K through 12 schools that said, yes, we'd love to have a hearing. I think most people think it's not a great idea to have 7th graders cross-examined by lawyers or non-lawyers about whether or not there might have been a sexual harassment occurred. But obviously under the Dear Colleague letter, live hearings were not mandatory at any level. Live hearings is certainly one of the aspects that have been highly criticized under the new regulations. Schools were very vocal that they felt they were A, not equipped, but B, shouldn't be holding these hearings, which essentially are looking more and more like an actual court hearing or trial when they're an educational institution. They're just trying to decide if somebody violated their policies or not, and how to get a complainant back to being able to fully access their education. There's requirements that at the live hearing time period, all parties have to be physically present in the same geographic location, or at the school's discretion, any or all parties, witnesses, or other participants can appear at a live hearing virtually. And where this sort of came up is sometimes, a complainant might not feel comfortable being in the same room as a respondent, and they would want to either not have the respondent there or testify from a different room. So schools at their discretion can allow that to happen. And then schools need to create an audio or audio-visual transcript or an actual transcript of any live hearing. At the university and college level, hearings have to allow for live oral cross-examination of the parties and the witnesses by the advisor to a party, which means that even if a party doesn't choose to have an advisor represent them through the investigation process, they do have to have someone there for the actual hearing, because the schools are not supposed to have the actual parties cross-examine each other or witnesses themselves. They're supposed to have an advisor as sort of a more neutral person do the questioning. The decision maker needs to permit each party's advisor to ask the other party and any witnesses all relevant questions, relevant being the key term there. The decision maker decides what is a relevant question or not. And if they decide a question is not relevant and does not permit an advisor to ask that question, they need to explain why they're deciding that this question is not relevant. I think that one of the best practices is for schools to try to do a sort of pre-hearing meeting with the parties, not necessarily at the same time, but one-on-one, that sort of will go over like what they think is relevant, what they think is not relevant. Ideally, if you can get the parties to agree that, you know, certain issues are relevant and certain issues are not relevant before you go into the hearing, and ideally in writing, that certainly makes the decision maker's job a lot easier here, and it also sort of sets expectations for the parties to make the hearing go smoother. I mean, you can't require that, but you know, advise parties that are well represented at these, I think it should be told that it makes sense to at least attempt to come up with those issues in advance. As I mentioned, the school has to provide an advisor to do the questioning without fee or charge to the party. And some schools have come up with really creative ways of doing this too. I know some schools have, if there's a sensitivity about having their own employees serve as an advisor where you're potentially adverse to another colleague or another student, that they have worked with other schools to create basically a sharing program where advisors from one, or people willing to serve as advisors from one school would, instead of advising parties at their own school, would advise parties at a different school, and they would sort of switch those investigators. The other thing is that if a party or witness doesn't submit to cross-examination at the live hearing, the decision maker can't rely on the statement of that party or witness in reaching a determination. That's a big issue that might change when we see what the Department of Education wants to do, because essentially if a party or a witness refuses to answer one of the relevant questions, then nothing that they've said can be considered, which strikes those of us that operate in court as a very odd conclusion to come out with, because that would is very unlikely to ever happen in a real court of law. Just quickly, other aspects of the hearing process is you can't restrict the ability of parties to discuss the allegations or gather evidence. The parties have to have an equal opportunity to present witnesses and evidence. The school's responsible for conducting the discovery. There has to be a disclosure of all relevant evidence, and you cannot use the grievance process to rely on or seek disclosure of information protected under legally recognized privileges like HIPAA, for example, unless that privilege is waived. Their evidence and documentation process, there has to be an objective review of the evidence. Again, the burden's on the school to gather the evidence. Schools have to provide an equal opportunity for parties to present fact and expert witnesses. Schools have to send the parties and their advisors what evidence they think is related to the allegations at least 10 days before the hearing so that the parties can inspect and review it. They can't access, again, the parties' medical, psychological, or similar treatment records. There's the rape shield protections for complainants, and the school has to send written notice of any investigative interviews, meetings, or hearings. One of the other highly debated issues under the new regulations is the requirement that they implement a preponderance of the evidence standard or clear and convincing evidence standard if the clear and convincing evidence standard is what you use in your faculty or staff allegations. So it has to be consistent for how you're going to treat students and how you're going to treat employees. The findings need to be written, and they need to be provided to the parties with 10 days to respond. And the decision maker's written determination needs to be whether or not there was a finding of responsibility or not, the findings of fact, their conclusions about whether or not the alleged conduct occurred, a rationale for the result as to each allegation, and what, if any, disciplinary sanctions are going to be imposed on the respondent, and whether any remedies will be provided to the complainant. And this written determination needs to be sent simultaneously to the parties, along with information about how they can file an appeal. As I mentioned before, if there's requirements for how a formal complaint is going to be treated. So what a Title IX investigator does first when they receive a report is decide, is this a formal complaint that meets the definition or not? They must dismiss the formal complaint if it does not meet the definition of sexual harassment, or it didn't occur in the school's education program or activity against someone in the U.S. But that doesn't mean they can't address the conduct at all. It likely probably falls within one of the school's other policies or codes of conduct that can handle that complaint. Schools may, in their discretion, dismiss a formal complaint if the complainant informs the Title IX coordinator in writing that they want to withdraw the complaint, if the respondent is no longer enrolled or employed at the school, or if specific circumstances prevent the school from gathering sufficient evidence to reach a determination. And then schools need to give the parties written notice of a dismissal, and whether it's mandatory or discretionary, and then the reasons for that dismissal. So remedies, they need to be provided to a complainant when the respondent's found to be responsible. Remedies is obviously a different term than supportive measures, and that's because remedies can in fact be punitive to the respondent because now there's been a finding of responsibility. They need to be individualized, so it can't obviously be the same that applies in every time you find someone responsible, regardless of sort of the certain circumstances of the parties. It can't be clearly unreasonable in light of the known circumstances. But the Department of Education, at least when it was coming up with these regulations, indicated that it was going to be fairly deferential to the school on what these remedies would be, as long as it wasn't clearly unreasonable. One of the final things to talk about is that schools are allowed to offer and facilitate an informal resolution process, such as mediation or restorative justice. Both parties have to give voluntary and informed consent, and they can withdraw that consent at any time. You can't require a waiver of a right to a formal investigation or an adjudication when the parties agree to an informal resolution process. This cannot be used in the circumstances where the allegation is against an employee. And then with appeals under Dear Colleague, schools weren't required to have an appeals process. The new regulations do require parties to have an appeal process. I usually put in there a time period for when parties must file their appeal, but basically the appeal has to be based on one of the following reasons, which are actually somewhat similar to what you would expect in an arbitration appeal. That there's a procedural irregularity, i.e. basically the school didn't follow its own policies, that there's newly discovered evidence, or that the Title IX personnel involved had a conflict of interest or a bias. And schools can include other bases for the appeal beyond that if they want, but they do have to tell the parties what those other bases are in advance. Massachusetts recently came up with its own law that addresses sexual misconduct on college and university campuses, potentially because they were concerned with what might be happening with the regulations as we sort of this pendulum swinging back and forth. A lot of the aspects overlap with Title IX. There are obligations to implement certain policies and procedures, including the Massachusetts one requires the schools to enter into an MOU with law enforcement about how they're sort of going to be handling Title IX complaints as well, especially when there's a law enforcement investigation going on simultaneously. There's notice requirements, mandatory training, and then annual reports to the state. So what to expect next? We sort of went over this at the beginning, but we do think that there's certainly going to be some changes, particularly with regard to some of the aspects that I discussed that were more highly debated. But it would be very surprising, I think, if all of the Dear Colleague letter provisions were put in place to just completely replace the regulations, because in the last several of years, courts have taken a look at both what happened pre-regulations and during the regulation period and weighed in on what they think should be happening. And it would be surprising and inconsistent for the Department of Ed to not take into account some of those court decisions. So in the meantime, OCR has confirmed that schools should be following the regulations as of right now until they get any more guidance or anything has changed. And that's what we have been essentially advising schools since President Biden's executive order came out. But certainly keep in mind that there's going to be changes to come and how to implement those changes. I know we wanted to reserve some time for questions or comments for all of you that are listening, so I'm happy to take any questions.
Thank you so much, Kate. And do you mind unsharing your screen so we can see everybody in gallery view? Awesome, thank you. So yes, now is time for questions. Please don't be shy. I know we've gotten several questions, Kate, about your PowerPoint, and if you'd be willing to share that so I can share that with everyone after the fact.
Sure, very happy to share that PowerPoint.
Wonderful. So yes, I will share that in the video, but now, what are your questions?
I don't know how to raise my hand in Zoom yet, but I do have a question. So thank you so much for your presentation. It was really informative. I represent a bunch of schools throughout Massachusetts in the elementary level and secondary level. And so I have been going through this process a little bit, and I'd be curious to know your thoughts on, with respect to the notice that has to go out to the parties at the beginning. There's a list of things that have to be in that notice.
Right.
My understanding is that the complainant is the person who the complaint was made on behalf of, but not necessarily the person who's the alleged victim, or I'm sorry, not necessarily the person who filed the complaint. So the victim, if the Title IX coordinator or someone else files the complainant is aware of it through supportive measures. But I guess my question is, it sounds like from the regulations to me, and I welcome your perspective, that the notice that goes out to the parties has to include the who. And so it would have, when I read it, I'm not sure if FERPA comes into play, but it sounds like you have to provide the name of the alleged victim in the notice. And so I'd just be curious about your thoughts on that.
Yes, and I think there has been, I don't think it's specific, it might even be specific. I think it might be in the preamble, at least to the regulations, that FERPA does not prevent you from sharing information related to the complaints. And it is certainly trickier in the K through 12 sphere, especially as the younger you get. But yes, so from the way I have counseled my K through 12 schools to do it is that they need to tell who, because you don't know you can't defend against the conduct unless you know who's alleged to have been harassed. And the regulations, and the preamble to the regulations, which, far outweigh on page numbers, the actual regulations themselves, were pretty specific that you need to describe like who the complainant is so that the person can respond to that. That is in part why I tried to counsel Title IX coordinators that at the beginning of the process, before you take the report in, you should explain. So for instance, if the report's going to be signed by like a parent or guardian on behalf of a student, or by your Title IX coordinator because the conduct sort of rises to the level where you want to go through this process, notwithstanding the fact that the parents and guardians don't want you to go through this process. Before, if you're receiving the complaint directly from the complainant or their representatives involved, I highly recommend the Title IX coordinators be like, okay, so just so you know, like you need to file a formal complaint. That notice is going to go out, and the notice is going to go out regardless of whether or not you find that the complaint is going to go forward or not, because if you dismiss the complaint, you still need to notify people who are involved. And it's I would imagine that when you're dealing with younger populations of students, it's even more sort of traumatic to sort of tell, like, you know, then you could tell, like, they're in their classroom or their smaller class sizes than at a university. Hey, like, Sally claimed that Robbie did X to her and Robbie needs to know. And then, you know, you're in a smaller school and that gets passed around and certainly could cause problems. So I suggest that telling people in advance, like, okay, if you want to file a Title IX complaint, just so you know, I'm going to have to decide whether or not to dismiss it or not. And when we make that decision, either way, the respondent's going to get notification of who you are, what your name is, what the allegations are, and you should know that, you know, like, they're not, if you decide to go through that process, you just need to understand that that's what's going to happen.
Thank you.
Yep.
I had a quick question.
Yeah.
I understand Title IX as it relates to discrimination based on sex. Are there any other equivalents for any other kinds of discrimination?
Yes. So Title VII, I should preface this, I am not an employment lawyer. So when I have Title VII issues, I kick them over to my colleagues in the employment group, but I can generally tell you that Title VII deals with discrimination in other contexts. There are not regulations that I understand that are as specific to how to deal with other discrimination complaints. Title IX is sort of where the focus, at least from the Department of Education's been on preventing those complaints. But oftentimes, what I've seen a lot of colleges and universities do, less so on the K through 12 end, is that they create a policy that prevents all discrimination, right? And you will weave into that policy, like, you cannot discriminate on the basis of race, you cannot discriminate on the basis of sex, you cannot discriminate on the basis of, you know, sexual orientation. And so, you know, you go through this very specific process if it falls within the Title IX definition, but there's still a policy in place that prohibits discrimination generally, and you would treat that like you would treat any other, you know, however you wanted to treat your code of conduct violations, which differ from school to school. But in my experience, I don't know of any schools that require like a live hearing requirement for discrimination under Title VII, for example, or discrimination on an other employment context, for example.
Thank you.
Yep.
I have a question. If you have a complaint where the complainant is in middle school and the respondent is in high school within a school district, is that handled or is that not handled because they're two different schools?
That's a good one. I haven't actually seen that come up yet. Likely, if it's in the same school system, I would counsel the client that generally you would want to go through that process, because I would want to be on the safer end of doing it than not doing it. The definition of what is in your school or school system's program or activities, I mean, you could certainly make the argument that it should be dismissed because you have one person in one school or one person in the other school. Because the school is going to have control over both parties, or the school system would have control over both parties, I think that would be, I would feel comfortable telling them to go forward with that investigation and process. The issue becomes, like, for instance, if you have a senior and they leave, then what do you do with the complaint if it's still going on? But frankly, in that circumstance, it's going to be a mandatory reporter issue on the other end anyway. So some of that's going to be taken out of your hands to some extent.
Okay, thank you.
And I know we're at 1 o'clock, but if anybody else has questions, you're welcome to ask them. All right. Hearing none, thank you so much, Kate. That was just a wealth of information. My mind is buzzing with all this stuff. So thank you for putting that together. And thank you everyone for being here with us. If you do have any follow-up questions, I'm happy to pass along Kate's contact information so you can reach out to her. Alumni connecting is always fabulous, and being able to be resources to each other is the goal.
Yeah,
So
please do
thank
reach
you.
out with questions. I know I talk fast, so some might percolate after this.
Definitely. All right, everyone. Well, thank you. Have a wonderful rest of your Friday. Good weekend if you have a weekend, and stay well.
Thanks.
Bye, everybody.